Good morning, everyone, or good afternoon, rather. Thank you for bearing with us as we work through a minor technological issue. My name is Angie Vosing. I'm the president of the Paralegals Association of Central Ohio, and welcome to today's Workers' Compensation Roundtable. I need to stop trying to do more than one thing at a time. Today we are welcoming attorney Mark Shaw, who is an attorney in the firm of Eastman and Smith here in Columbus. Mark represents employers in workers' compensation, litigation, and employment matters. He has represented both private and public sector employers before state courts and at all administrative levels before the Industrial Commission. He has experience with construction businesses, healthcare companies, insurers, manufacturers, and transportation and logistics companies. Additionally, he has represented insurers in professional liability matters. He also is active in the Ohio Chamber of Commerce Workers' Compensation Committee, which monitors and recommends workers' compensation litigation in the General Assembly. Welcome, Mark.
Thanks, Angie, and good afternoon, everyone. It's my pleasure to speak to you today about what I think is a very interesting topic and a very topical topic, if you will. It's been in the news a lot, and it really affects kind of all of us in some way or another, whether it's in our personal lives as we see this coming into our society here in Ohio, and perhaps in our professional life through all your work as paralegals and our work as attorneys and in the legal profession. So I'm really excited and appreciate the opportunity to speak with all of you today. A brief kind of outline of what we're going to try to cover today, and I obviously welcome a lot of interaction. So if there's any questions, feel free to either chime in verbally or use the chat function. I believe Angie will be monitoring that. So happy to go off topic, talk about anything related to this or any other question you may have for that matter. So we're going to kind of start with just outlining kind of what issue 2 was and is as far as here in Ohio, and that's obviously the recreational marijuana issue that was passed. Talk about kind of what that was, kind of some statistics about what the pre and post-election kind of polls were, kind of how it passed, what the law actually does, and then we're right in the middle. If you're following this, the legislature is literally changing this by the day because they have the power to. And we'll talk a little bit about that and some of the changes of that the House and Senate are currently going back and forth on to amend and to change some of the provisions that were in issue 2. We'll then talk about kind of how this issue affects employers and obviously employees, because you can't have an employer without employees. So it certainly will affect everyone, whether and we're all employees to some extent, and certainly some of us are employers, and we represent employers sometimes. And then we'll kind of conclude with how this affects safety in the workplace. And I know this perhaps is some of you are workers' compensation paralegals, and that's great. I love all of you for that. And we'll talk about how this may affect workers' compensation in particular, and mainly the rebuttable presumption statute and how that works on workers' compensation. And we'll kind of go from there. So just to kind of recap and get started here, issue 2 was a little different. If you remember back in November, there was a lot of talk about issue 1 and issue 2. Issue 1 was the reproductive issue, and that was a constitutional. That was the voters were asked to actually amend the Ohio Constitution and put in provisions related to reproductive or abortion type issues. Issue 2, on the other hand, was for recreational marijuana. That was a citizens initiated statute. And what that means and how that got into place was the supporters of issue 2 had to collect 3% of the registered voters in the state of Ohio to sign an initiative to put this on the ballot. Once they obtained those 3% registered voters' signatures, that this provision, the recreational marijuana statute, was then presented to the legislature to adopt. And if they didn't adopt it or they didn't act, then it went back to the supporters to collect an additional 3% of Ohio voters to sign, and then that would allow it to go on the ballot. So that's how it went on to the Ohio ballot in November. And we all, as registered voters, voted on that, whether you voted yes or no. And so that's why it's a little different than issue 1 on the reproductive side. And so what that means, and we'll talk a little bit about it, is that it's really a statute where the legislature now has the ability to change and modify some of the provisions in what was voted under issue 2. And we'll talk about that. But before we get into that, I wanted to just briefly talk about kind of some interesting statistics about kind of how this issue was perceived by the voters. Issue 2 was passed by 57% of the voters. It was 57 to 43. It was fairly positive in the sense that voters in the state of Ohio wanted recreational marijuana. It passed surprisingly in 40 of the 88 counties in the state of Ohio. So you had not only urban counties voting for this issue, but there were some of the rural counties that also voted in favor of issue 2. We'll show a map here in a second, but Ohio has become the 24th state to legalize recreational marijuana. And you may recall that several years previous to this year, Ohio had, the legislature had actually passed a medical marijuana statute. So medical marijuana has been legal in the state of Ohio for several years, and that's been up and running. And now citizens in the state of Ohio have decided to have recreational marijuana. And again, we talked a little bit about this citizens initiated status, but that was voted for on November 7th, and 30 days later, it became law. And now the legislature is still providing some implementation legislation. We'll talk about that. But as of last Thursday, recreational marijuana was legal in the state of Ohio, although you couldn't buy it anywhere legally, ironically. So we'll see how that's come. We'll talk a little bit about how that's coming into play over the next 9 months. And because this was a citizens initiative statute, this statute cannot be vetoed by the governor. Governor DeWine cannot veto it. So just some interesting statistics here on kind of how this was viewed. And I have kind of the ballot language, the major part of the ballot language there listed for you. And I think the pre-election polls were pretty accurate. You had, prior to the election, 59% of Ohioans were supporting the issue versus 32 that were not. Obviously, that came out to 57-43 at the end. And you can see in this pre-election poll, it was fairly across the board as far as the political spectrum. 68% of Democrats supported issue 2, 48% of Republicans, even though that was less than 50%, it still was 58-46 over that party, the Republicans that did not support issue 2. Independents supported it 62-28. And then you can see from a demographic standpoint, as far as age demographics, younger people overwhelmingly supported the issue. 18 to 44-year-olds supported the issue prior to the election by 68 to 27%. Even 45 to 64-year-olds supported issue 2, 62 to 28. And surprisingly, even 65 and older, at least pre-election, had support for 46 to 42% of the for the issue. And then across various ethnic groups, it was also supported. So in the state of Ohio, this was, I think, certainly most people thought it was going to pass. It did pass. And then as far as what actually happened, you can even see even the younger voters, the very younger, earlier voters, 18 to 24, supported this issue by an 84% approval rating. So it was very popular. Even the 30 to 44-year-old demographic group supported this, almost 70%. And you can see the other groups there that supported this. Now, comparing this to issue 1, which again was the constitutional amendment on the reproductive and abortion issue, that passed almost similarly, about 57 to 43. So both of those issues on the ballot, even on what some consider an off-year election, was popular and passed. I think one of the big issues that Ohioans may have gone into, some of them at least, supported the issue. It's projected to raise a lot of revenue for the state of Ohio. And here you have a study that was done by Ohio State back in 2022, where about $300 million of tax revenue into the state of Ohio to be distributed to various areas where the legislature is currently kind of going back and forth as to where that tax money should go. But by the year 5 of this implementation for recreational marijuana, it's projected to provide about $300 million of revenue to the state of Ohio. Kind of on a comparison basis, Michigan in 2022 had 281 million. And Michigan has had recreational marijuana legal for several years, well before Ohio has just passed that. So here's this kind of a map of what you see throughout the United States. The dark green being states that have passed recreational marijuana. The light green states have passed medical marijuana, but not recreational marijuana, at least yet. So if we had put this map up a year ago, Ohio would have been in the light green, but now we've gone over to the dark green shade, and you can see the other states that have also passed recreational marijuana. And it's interesting, I have been presenting on this topic for about between 5 and 7 years, basically. And we first started this when kind of the medical marijuana initiatives were going through the state of Ohio. We would kind of have this map in our presentation, and there were a lot more gray states throughout the state of Ohio, throughout the United States. And here you can see there are only 13 states now in the United States that have no form of legalized marijuana, either recreational or medical. And as may or may not be surprising, kind of this movement of marijuana through either medical and recreational started on both the West Coast and East Coast. You can see both of those generally have wide support for both medical and recreational marijuana. And kind of the central part of the United States is now starting to fill in. And I would think probably within the next 10 years, you may see all green on this map. But we'll see, and we'll talk about in a minute here about kind of how the federal government perceives marijuana. And it's a little different than what the states have at this point. So that's interesting to look at from map standpoint. So those are just some of the kind of background about issue 2, kind of how it was supported in the state of Ohio, kind of how marijuana is throughout the United States and the different states. So let's now talk about what the citizens of the state of Ohio voted for in issue 2 back on November 11th. And here's the basics of the new law. Ohioans 21 years and over under the law could possess up to 2.5 ounces of marijuana and 15 grams of marijuana extract. A big provision of the law that I think a lot of people supported the law for was that it would, I think one of the thoughts was that it would kind of get rid of the black market, if you will, the drug dealers, the seedy side of marijuana, if you will. And so one of the provisions that the supporters wanted in the law was this ability to grow marijuana at home. And so the law has, that was voted for, that each single adult could grow up to 6 plants in their home, his or her home, and up to 12 plants if there were 2 or more adults in the home. And we'll talk a little bit about how and that's one area that the Senate and the House in the state of Ohio are going back and forth now about whether or not that should remain or that should be altered. We talked about the tax revenue. The law that was voted for had taxing of marijuana at 10%. So if you went out and bought marijuana, you would be taxed at 10%, as opposed to if you just go buy something, sales tax in the state of Ohio is, I think, 7.5%. So obviously the law was intended to have benefits to the state of Ohio from a tax perspective. As we talked about, recreational marijuana is legal in the state of Ohio now. It was as of last Thursday. And we talked about that it can be amended, and we'll talk about those amendments that are going back and forth right now. The other part of the law, and that I think supporters wanted to make sure, was that this new law would have no effect on the current medical marijuana program. So all of the conditions that people are allowed to get marijuana for under a marijuana card from a healthcare provider have not changed. So that remains into effect. So we just talked about what the law was voted for by all on November 7th and what was in that provision. And because it was a citizens initiated statute, now this is going back and forth last week, this week, it's going to probably go into the early part of next week or next year. The General Assembly is going back and forth on some of these provisions. And I gave a presentation last Friday on this, and as of Wednesday, when I was preparing some of those slides and some of these slides, these were some of the proposed changes to issue 2. We talked about that possession amount. The possession amount that the General Assembly was contemplating was reducing that possession amount from 2.5 ounces to 1 ounce, reducing the grams of extract from 15 to 5, setting certain limits on the amount of THC, which is the part of the plant that gives the not the hallucin, but the kind of the high feeling from this drug. It also capped the amount of dispensaries that were going to be able to provide recreational medical marijuana at 230, and it prohibited any of these dispensaries from only selling recreational marijuana. So it had to provide both medical and recreational marijuana. The other, again, apologies in advance to anyone that has family members in the General Assembly. They're all great people, but of course they see an opportunity here to increase the tax rate from 10. Why not increase it? So they did contemplate, and we're debating and still debating about whether to increase that tax from 10% to 15%, and include even an additional tax on cultivators, the growers and the cultivators of the plants, which was not in the original issue 2 that voters voted on. The other, another hotly debated change that the Senate was proposing as of last week was the complete elimination of the homegrown provisions. Remember, each single adult in a home could grow up to 6 plants of marijuana. 2 adults could grow up to 12. There was initial provisions of the Senate bill last week that was going to eliminate all. Now, ultimately they didn't, and we'll talk about what actually passed late Wednesday night last week, but that was one of the issues that they were contemplating. And then another big issue that people have is about, we all know over the years how just general cigarette smoking has kind of gone away from public venues, if you will, restaurants and those things. And so a lot of people were concerned that would that be available? Would you go to a restaurant and somebody sitting next to you be able to use recreational marijuana? Well, I don't think that's going to happen, and certainly the legislature is prohibiting all public smoking, vaping, and combustion of these, and that you would only be able to do it in your private residency. But before I get to how this affects employment, so we talked about what a lot of those were what was being thought about by the Senate last week. What actually passed at midnight, well, it passed late on Wednesday of last week. The Senate passed their changes 28-2, so it was pretty bipartisan, and they have all of these changes that they've added are now been sent to the House for discussion, and we'll talk about that here in a minute. But what the Senate passed and the changes, and I'm going to just talk about kind of the major changes. I apologize, I don't have a slide for these major changes because it was so new and it's not been definitively determined because the House still has to consider it. But remember, as the slide shows, the House was, or the Senate was initially contemplating completely eliminating the homegrown. Their bill that passed limited home growing to 6 plants per household. So they got rid of the 1 adult, 2 adults, 6, 12. They're just saying you can grow in one household up to 6 plants per household, no matter how many adults you have living in that household. And they also have provided some guidance as to what a quote unquote household is. So that was one change. So from up to 12 plants in a household, the Senate has said you can have up to 6. They kept that increase in the tax from 10 to 15% on the excise tax. So you'll be taxed as retailers if you go out and purchase some recreational marijuana. You'll pay 15% on that. But they eliminated. They had talked about putting a 15% tax on the growers and cultivators. They did eliminate that tax. Some other key provisions, they set certain limits on the THC, again, that substance in marijuana that provides the high. They limited that to 35% for plant material and 50% for the extracts. They capped the dispensaries. I think this last slide had indicated that they were contemplating capping the dispensaries that could actually sell recreational marijuana to 230. Ultimately, they capped that at 350 dispensaries. So there'll be 350 locations throughout the state of Ohio that people can go and obtain recreational marijuana, assuming that passes the House. Perhaps the biggest one, and I wanted to just briefly talk about it because it's going to get a lot of publicity, is the Senate, to gain both, I think both Democrats and Republicans to support their changes, they included an expungement provision. So what that means in an expungement is that people that have been convicted of marijuana crimes previous to this law coming into effect, all of those convictions will be expunged if their convictions met the current law that will be ultimately in place. So if 5 years ago you were arrested and convicted for a marijuana crime that's now legal, that conviction will be expunged from individuals' records. And that's a big one that the legislature has put into the new law, or that they're certainly being contemplated to do. The Senate also gave municipalities the power to ban recreational marijuana businesses. So if it doesn't mean they can ban the use of recreational marijuana by citizens within their municipalities, but they can ban the businesses. So they can ban the ability to grow marijuana. They can ban the ability to sell marijuana in certain municipalities if they so choose. Another big one was that, and we'll talk about this, it retains the language for employers to make hiring, firing decisions, their drug-free workplace policies. There's no changes to any of those. So employers will be able to hire and fire individuals that violate their drug-free workplace policies, assuming that they have them. We'll talk about that as well. Briefly, the House now is literally in the process of considering those changes. And they, of course, not surprisingly, have their own ideas on how this law should go into effect. And just some of those that we've been following, and just to make you aware of, the House has a little bit differences, and I won't get into the weeds too much, but they have some differences on how the tax revenue should be shared and divvied up. They want to maintain the 6 plants per person, but they want to go back to the original law and include the up to 12 plants per household. So we'll see about how that ultimately shakes out. The House also is interested in putting in some provisions in the law to make marketers of marijuana so subject to the same regulations as alcohol and tobacco. And it's interesting, you know, I don't know if any of you have gone to other states. When you drive right into the states, like for example, you drive up into Michigan, as soon as you cross the border in Michigan, either on I-75 or Route 23, going into Michigan up there in Northwest Ohio, you are immediately inundated with billboard after billboard after billboard after billboard of marijuana, I guess, dispensaries where you can buy marijuana. It's almost like as soon as you go into that state, here you go, you can immediately go buy your marijuana. I don't know if Ohio will put provisions to prevent that. I mean, you don't see cigarette and obviously you see cigarette and alcohol advertising in certain locations, but I think the legislature wants to be very careful about just inundating their citizens with advertising about this new drug that will be legal now in the state of Ohio. So we'll see where that goes. They also want to limit public smoking of marijuana, similar to tobacco. One of the bigger provisions that was not in that Senate bill that the House is contemplating, and this is really interesting for perhaps some of you that do other areas of law, like real estate. The landlords were very concerned about when they rent their house, their apartments to individuals, that they wanted the ability to prohibit tenants from either using or growing marijuana in those houses or apartments. And so there is a movement in the House to limit some of that. And certainly, if they can't limit the ability of individuals to use a legal product, they certainly are trying to eliminate growing of marijuana in those types of situations. So if you have a house or an apartment that you rent to a tenant, you may be able to prevent that tenant from at least growing marijuana in the apartment or the house. So that's a big one that the House has come up with. Obviously some other ones were the House really wants to put up some guardrails, if you will, for how homegrown plants are not going to be accessible to children. I think there's a lot of concern about just how this, just generally the overall marketing of the edibles, see the gummies you may have heard about that are marketed to will be illegal or that will be legal to adults. They want to make sure that they're not being targeted to children and children are getting those. Same thing with the growing of marijuana in homes. They want to make sure that children are not easily accessing homegrown products. So those are kind of some of the basics of the law. Happy to answer any questions about that now, or if you have any, we can save it or ask any questions now before we move into kind of how this law is affecting the employment and workers' compensation issues. So from a employment standpoint, we talked a little bit about this. How does recreational marijuana affect employment or employment law, or if you're an employee or an employer? Issue 2 really provides really broad protections for employers to refuse to hire. There's no duty to accommodate an employee's use, possession, or distribution of marijuana in the workplace. And that was the same with medical marijuana. There is no duty on an employer to accommodate someone's legal use of medical marijuana, and same thing now with recreational marijuana. Employers can refuse to hire anyone that uses or possesses marijuana or distributes marijuana. They can discharge, discipline, and take any other adverse employment action against an employee based upon that same use, possession, or distribution. Employers' drug-free, zero-tolerance drug-free workplace policies can prohibit the use of marijuana, even though it's now legal, both medical and recreational, during working hours or while under the influence of marijuana. So obviously, employers can't stop individuals from using a legal product on their own time in their own home, but they can certainly prevent employees from coming into the workplace and exposing themselves and their coworkers to potential dangers if they are under the influence and impaired by marijuana. So that's been a big sticking point for employers in the state of Ohio, that they wanted to make sure that that's the case. And we'll get into a little bit about really the studies that have shown states and how this has affected safety in the workplace. And it's unfortunately not great, and we'll see if that happens in the state of Ohio. But before we get to that, I wanted to talk just briefly and alert you to really what's really a kind of an interesting issue from a legal standpoint. We showed you the map. I showed you the map here where all of medical marijuana and recreational marijuana is now legal, and it's really overtaking almost all of these states. And we talked about how 13 states, only 13 states now where it's illegal, either medical or recreational marijuana. Well, how does that play with federal law? Well, remember, under federal law, marijuana is still a Schedule I drug under the Controlled Substance Act. And that means under federal law, it's still illegal. Now, there's been some give and take between the federal government and the states, and there's going back to when the United States became the United States, there's always this tension between federalism and state rights. So I think there's always been a recognition that the states are going to move forward with this, but the federal government, at least as of now, has said that no, we're going to continue to have this as an illegal substance and list it as a Schedule I drug under the Controlled Substances Act. Same thing with the Department of Transportation. If you're in a a transportation-related industry that's governed by DOT. It's still unacceptable for safety-sensitive employees subject to drug testing under the Department of DOT drug testing regulations to use marijuana. That's not changed, even though a lot of these states have legalized marijuana in some form or fashion. But there's always a big but with some of these things. Under the federal government, we're starting to see that position erode. And it really didn't, it's actually been eroding for some time. But specifically, there's 3 events here that I have listed where you can see kind of this changing under the federal system. About a year earlier this year in January, so January of 2023, there was a House resolution introduced by the House to change marijuana from a Schedule 1 to a Schedule 3 under the Controlled Substances Act. And that would open up a lot of issues regarding the legality of marijuana use among citizens in the United States. In addition, I think this current administration under President Biden is for or would support that. And certainly President Biden did last October pardon individuals that had been convicted of simple marijuana possession offenses under federal law. And so that was one of the things that he did to kind of pardon these individuals. Now, that was not effective on state offenses. It was only for federal offenses. And then just a couple months ago, there was a letter from the Health and Human Safety Service Department recommending that, again, this idea that any marijuana, not medical, but just marijuana be rescheduled from Schedule 1 to a Schedule 3 under that Controlled Substances Act. And that was a recommendation to DEA, the Drug Enforcement Agency, to do that. Unfortunately, or fortunately, depending on how you view this, the DEA on 4 prior occasions has refused to do that. We'll see if that happens now, but it has been requested 3 or 4 other times, and they've not done that. So, but you're starting to see by all of these things that under federal law, the use of marijuana and how marijuana is perceived at the federal level is even starting to erode. So from an employer's perspective, here are just some concerns that I think marijuana presents to employers that we've seen or heard from our clients based on this movement over the last 10 or 15, 20 years from marijuana becoming more legal from either a medical or recreational, is it's really hard, certainly in this type of economy that we're seeing, which is kind of a booming economy, if you will, at least from an employer perspective, an employment perspective, it's really hard to find qualified workers to come in and be employees. Particularly if these employers have these drug testing requirements. A lot of the folks are not passing the drug test, so they can't be hired under their policies. You're seeing, we talked already about a lot of the state and local laws are just always changing, and it's hard to, as an employer, to keep up with all the different changes from a compliance perspective, particularly employers that have multi-jurisdiction operations, either through the state of Ohio or through multi-state operations. So we're seeing a lot of just trying to keep up with all the different changes. Again, that map shows you over the last 10 years how all of the different states have changed. And if you're operating a business in multiple states, it's hard to keep up with all the different changes. A big issue that this presents is how do you measure impairment versus presence of marijuana? Just because testing reveals that there's some presence of marijuana in your system does not necessarily mean that you are impaired because of that. And everybody is different, just like alcohol. You know, one drink may create a whole different effect on impairment on one person, depending on a lot of different factors, versus another person. And that's the same thing with marijuana. So proving impairment has been difficult for employers. We talked about kind of this changing attitude and laws that this movement has brought on legalization of marijuana, and just kind of all the different enforcement actions that have taken place in courts and all the different proceedings. So, you know, there's how employers have to be nimble and meet their employees where they are. And there's certainly been a lot of changing attitudes towards a relaxation, if you will, of marijuana, and how are employers going to deal with that? Obviously, safety is there probably a super big concern and issue for them, but they also need to balance that with obtaining qualified workers and enough workers to produce and to do what their business requires. So that's always a kind of a tension. We talked a little bit about kind of this, you know, how do you, there's some jurisdictions kind of where this originated from in California and Washington, where there's now laws that protect off-duty use of marijuana, even though that marijuana may have been utilized or used off-duty, people are still coming into the workplace impaired, but certain jurisdictions are now starting to protect those individuals. And if it can be proven that that use was done off-duty, then they may be able to be protected. And then there's just a couple other ones there that I have listed. So it is a big concern for employers. Just be aware of that, and we'll see, kind of like everything, how this evolves. What's on the horizon for some of this? I don't, whether it depends on where you are and on this, but I think 20, 25 years ago, it would have been hard to imagine that all of these states would have legalized marijuana, and recreational marijuana now is really kind of prevalent. So where are we going as a society in this? A lot of movements now are starting to develop and bubble up on these use of psychedelics. You may have seen some of the research and some of the issues with use of this product to treat anxiety. And there's some, I think, very reputable studies that indicate that it is an effective use to treat certain anxiety-related symptoms and conditions. So we'll see if that takes place, and maybe we'll be talking in 5 or 10 years about the new Ohio psychedelic drug law, but we'll see if that happens afterwards. I don't know. Let's move in then. I know we're moving along here on just kind of how this whole movement has affected workplace safety, at least with some of the studies that we have shown. You can see here from 1995 to 2021, the percentage of marijuana and cannabis samples seized by DEA has risen dramatically, here down from 5% to up to almost 20%. So that kind of corresponds with the proliferation of marijuana being legalized in all of these different studies or different states. Some of this slide may be a little hard to kind of get the exact details, but there were earlier this year, Quest, the big lab, sent out or published a study that they had been doing for many years, and you can just see how the post-accident drug testing over the last 25 years kind of started at a certain level, and then as it got down into maybe 2010, 2011, it hit kind of more of a low point. But once a lot of these states started legalizing marijuana, either on a recreational or medical basis, the post-accident drug testing has risen quite dramatically in the last 10 years. So these tests that are being done post-accident are showing a lot more positive tests for marijuana. And employers, as we talked about, are very concerned about how that affects safety to not only the individual that's using marijuana, but to all their coworkers. And that's a significant issue for employers. Some other findings that we talked about this. There was a 204% increase in positive post-accident drug tests for marijuana in the last 10 years. That's quite significant. Just in from 21 to 22, these marijuana post-accident drug positive tests increased over 10%. States with legalized recreational marijuana had a higher positivity rate than states without legalized marijuana. Almost 12% of states with recreational marijuana were showing positive tests versus 3%. And some of the industries that had the largest positive rates were in the hospitality and food service industries, the retail, and finance and insurance sectors. So some of those were some of the significant findings from that study. Even other studies showed, these were two studies, and if you followed this, Colorado was one of the first states to legalize recreational marijuana, along with, I think, California and Oregon. But there was a study from last year that states that had legalized recreational marijuana showed a 24% increase in marijuana use among its citizens. And then the University of Pittsburgh, about the same time, issued their study where it correlated the use of recreational marijuana with alcohol consumption among individuals 18 to 24-year-olds, and showed that it did, the use of legalized recreational marijuana did have an increase in alcohol consumption among that demographic group. So how do we put all this together? I thought it was maybe a fun little thing to put together, and would welcome any input that you have, and kind of put a scenario together about how this actually may apply to the workplace. So here's a scenario that you can read on yourself. I can read it out loud, but you are the HR manager at a toy store. Holly, of course, works as a seasonal employee in Santa's workshop. One day, of course, a box of candy canes falls off the shelf and hits her on the head, causing a concussion. You, as the employer, have a zero tolerance drug testing policy at that hospital. And at the hospital, Holly undergoes that post-accident drug test, and she tests 8 times the test cutoff. Your policy also requires that if an employee tests positive for marijuana, they will be terminated. And Holly claims that she was at a party with her friends 3 days earlier, and she used marijuana legally at that party. She's an adult, and she used it legally. How in the world can she now be terminated? So I asked the question, and anybody can chime in. Do you think that Holly can be terminated under Ohio's new law? Well, if you answered yes, you are probably right. Remember, issue 2 provided all these broad protection for employers that if you have a zero tolerance drug policy for the use of marijuana, you can still enforce that policy if Holly presents and is in the workplace, has an accident, it's tested under that policy. Policy is been communicated. She knew about it, and it's a valid drug test, and it's done properly. She can be terminated under your drug-free tolerance policy. So Holly can be terminated, unfortunately, even though it's the holiday season. That seems mean, but Holly can be terminated if the employer so desires to do so. Here's some practical considerations that employers may want to consider that on these drug-free policies. You know, a lot of times we see employers that have drug policies that were drafted and implemented well before either medical marijuana or now recreational marijuana were legal. And a lot of these policies simply say or have the language that we do not allow for any illegal drugs in the workplace. And so your policy is for illegal drugs. Unfortunately, now for them, if they want to use that policy, if they haven't updated it or that policy, the use of medical marijuana and now recreational marijuana is a legal drug. So under that policy, it may not be applicable anymore for marijuana. So we always advise our clients and employers to review your drug-free workplace policies, ensure that if the company wants to, that they include marijuana in that policy, because the law does provide for them to do so. If they so desire, include marijuana in that drug-free policy, even though it's obtained through a state-sponsored legalized program. Obviously, we would also and always, whenever you're updating your policies, make sure you communicate and notify employees that, and it's probably even just good sound practice, even if your policy included marijuana before December 7th, that you communicate that you're still going to be enforcing that policy, even though marijuana is now legal in the state of Ohio. So those are just some practical considerations. So a quick bonus question for you all here, and I know we got to get going here because we got 2 minutes or so, and I know you got to get back to your things. What about on the workers' compensation? Remember, under workers' compensation, there is a rebuttable presumption statute that if somebody tests positive for a post-accident drug test, there may be a rebuttable presumption that they're, I don't know, is there a question from Linda maybe? I don't know, got her hand up.
Sorry. I did have a question about the company policies. If you have
Sure.
a zero tolerance drug policy, if somebody is using recreational marijuana outside of the workplace, and it's legal in Ohio, can the employer set a limit or just simply notify them like it's illegal, period? I'm a little confused on that.
Sure. And that's kind of the tension that's out there. But if most policies say that you can't, employers can't prevent individuals from using a legal substance like alcohol. I don't think employers could say, you can't in your own time drink alcohol, a glass of wine at home with your spouse for dinner, and we find out about it, you're going to be terminated. That would not be proper, and that would not be legal. Same
Correct.
thing now with marijuana. You can't tell people they can't use a legal substance and have a policy that says that. But what you can do as an employer is you can have a policy that if they decide and choose to use that legal product, they can't come into the workplace with that in their system. Same thing with alcohol. And it's no different than what individuals and employers have had with alcohol. You can't come into the workplace impaired either through alcohol or marijuana. So hopefully that answers your question about whether or not employers can't prevent individuals from using a legalized substance, but they can prevent them from coming into the workplace impaired or having the presence of that substance. So if some of these employers have random drug testing, if you have a random drug testing policy and say somebody used marijuana 3 days ago, it's still in their system, and your drug policy you cannot have the presence of marijuana in your system. If they get caught in that random drug test, they can be disciplined up to and including termination, depending on what the policy says.
Great, that clarifies it. Thank you very much.
Sure. Again, just briefly on this workers' comp, there is that rebuttable presumption, and there's certain things under the rebuttable presumption. It's not automatic. The rebuttable presumption means that if an accident is occurs and somebody's under the influence of drugs or alcohol, there's a presumption that the proximate cause of that accident was the presence of alcohol or marijuana in their system. In order to take advantage of that presumption, again, it's rebuttable, so the injured worker could rebut that, but in order to take advantage of that, here are the requirements for that rebuttable presumption. It obviously must be posted that there is this policy that if you have a accident that you may be subject to post-accident drug testing. A lot of times that posting now is on the BWC certificate. So if that's listed at the employer workplace, you're going to see that notice on that BWC certificate of workers' compensation coverage. But the big one is whether or not the testing is a qualified chemical test. And a qualified chemical test is one that it's actually kind of hard because the employer, you just can't have necessarily a post-accident drug test 100% of the time and say that that post-accident drug test is a qualifying chemical test, because the qualifying chemical test either has to be one that the employer had reasonable suspicion that the employee was using or under the influence of whatever substance you have, which is alcohol or drugs. And that reasonable suspicion has to be documented. So there has to be witnesses or supervisors that witnessed the individual prior to his or her accident acting irrationally or acting stumbling, slurring their words, or some suspicion that they may have been under the influence. So there has to be documentation of that to make that post-accident drug test a qualifying chemical test. The other two provisions are whether a police officer requires the test. So if there was an accident, the police officer requires, law enforcement officer requires the test, that could meet a qualifying chemical test, or a physician at the hospital that's not employed by the employer. So those are the provisions. In Holly's case, this was if you remember the facts of it, where is it here? There probably was no reasonable suspicion. She, assuming there was none, she was acting normally. This candy canes, this box just fell off the shelf and hit her on the head. So there's probably not a reasonable suspicion to have tested her. And under these facts, it was just done pursuant to the policy, which is fine. You can still have that policy. You just can't take advantage of the rebuttable presumption. And it doesn't appear that the test was done at the direction of a law enforcement officer or a physician at the hospital that required it. It was done pursuant to your policy. So it's unlikely that Holly could, or the employer could, take advantage of the rebuttable presumption under the law, but there is there's one other way to do that is, can the employer prove that the proximate cause of her accident was the box falling off the shelf was the proximate cause of her injury, the use of marijuana in this situation. Under these facts, it's probably not, because even if she was so high she could barely walk, these facts indicate that kind of this box just simply fell off the shelf and hit her on the head. Really had nothing to do with the level of marijuana in her system. So even though that's employers could take advantage of that, in these facts, it's probably not going to happen. That was the proximate cause. It was just a fluke accident, and she's probably going to get her claim allowed under workers' compensation. So I know I ran a little over time. Happy to answer any questions or stay over and talk to anyone, or shoot me an email. I do have my email there on the slides right there, and happy to answer any questions. But I really appreciate the opportunity to speak to you today, and thank you, Angie. And
Okay, great.
About your organization.
Great. Thank you so much, Mark. We appreciate your coming and sharing your expertise with us. We do, excuse me, also thank all of you for taking the time out of your day to join us. And as always, we thank Spectrum Reporting for providing our Zoom link and recording today's session. Next month, we will meet on Thursday, January the 18th. Dr. Bradley Lewis, who is the BWC's Chief Medical Officer in the Office of Medical Operations, will be joining us, and he may have one or two other people with him. I haven't gotten confirmation as to exactly who is speaking, but they will be speaking to us on the topic of the opioid crisis in Ohio and what the Bureau of Workers' Compensation has done to address the issue of opioid use, and also the requirements that a physician must follow in order to continue to prescribe opioids in the acute, subacute, and chronic phases. So that information will go out soon. We hope you'll join us. Thank you, everyone, and have a great day.